Great, thank you. Welcome, and thank you for joining Seyfarth's webinar, Washington Long-Term Care Act, What Employers Need to Know. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Liz Deckman. Liz, you may begin.
Hi, thank you, Kim. Welcome, everybody. I'm so glad you're here and joining us to talk about the Washington State Long-Term Care Act, what employers need to know. Kim, would you forward the slides a little bit? 2 slides, please. So this is a new act for Washington State. It's a new act for the United States. It's one of a kind and may actually be the first of its kind. We'll see what happens throughout the United States to see whether or not this type of law is replicated in other jurisdictions. But because the law is so new, we have a group of 3 experts here to talk to you about different aspects of the law. My name is Liz Deckman. I'm a partner in the Seattle office of Seyfarth Shaw. I'm an employee benefits attorney. And joining me at Seyfarth Shaw's Seattle office is Helen McFarland. She's also a partner, but she practices in the employment law area. And we are very, very pleased to have Christine McCullough, who is the president of LTC Solutions, Inc. She's in Redmond, Washington. Christine is a nationally recognized leader in this particular area, group long-term care insurance. And I know she's been very busy these last few months and probably up through November. And so we're glad that she can be with us today. Next slide, please. So here's the agenda. We're going to talk a little bit about what is long-term care, some basics so that everybody is on the same page when we start off. Then we're going to talk about the background of the Washington Cares Fund. What happened, where does it come from, who is going to be involved with it. Then we're going to do an overview of the Trust Act, the benefits, who's eligible, what employees need to know. Christine is going to talk about what qualifies as private long-term care insurance, because that will be important if people want to opt out of the program. Helen is going to talk about employer responsibilities. And at the end, we're going to have some Q&A, as Kim told us at the beginning. So with that, I'm going to turn it over to Christine.
Good morning, everyone. And I will first be going through the basics of long-term care to make sure we're all on the same page. So if you want to go to the next slide, Kim. So what is long-term care? Well, you'll hear the word custodial care. That is when care is not restorative in nature. You're at a level of care that you will always be at. And that level of care is defined if you need assistance with an activity of daily living. And you'll see we have 6 of them listed here. And typically when you need help with 2 out of 6 is when that will trigger a long-term care policy. Or you could need help due to cognitive impairment. You need some supervision. Both of these types of defining the type of care you need, ADL help or cognitive impairment, was implemented with HIPAA when they basically modified or kept all the long-term care plans qualifications the same. And that's an important point to make, because you'll notice with the Washington law that triggering mechanism is a little different. If we go to the next slide, please. So what's the big deal about it all? That's what everyone wants to know. Well, a lot of people don't realize how risky it is that someone may need long-term care. So we thought it'd be, interesting, compare it to the other risks that we face in life. Hopefully that none of these we incur. The first one is, if something happened to your home, it caught on fire. Well, there's about a 3% chance that could happen, and we don't see it often. A car accident, you're going to see a 2.3 chance. That's a little bit about the same. And then the fact that you'll need disability, that you'll become disabled. That's a 12 and a 12.5% chance that'll happen. But the chance that you're going to need long-term care at some point before you pass away is a 70% chance. That's a large number, and a lot of us don't realize it. The longer we live, the more exercising we do, the healthier we eat. That is what is the consequences. You live longer and might need long-term care. If we go to the next slide, the big issue is the cost. How do we pay for care? So here in Washington State, the average cost of care in your home is about $72,000 a year. Now, this type of care in your home is where someone might come in a couple hours to 4 hours a day, 3 to 5 days a week. This is not 24 hours, 7 days a week care. That would be much more expensive than even a nursing home stay. Then we have assisted living, and that is, like I call it, resort or dormitory living. And this is where you go to a place and you can pick a 1-bedroom, a 2-bedroom. They have activities for you. They prepare your food. They can do your laundry. And some parts of it sound wonderful. And that average stay of care is about 2.5 to 3 years and running about $69,000. And then we have the nursing home. Truly, about 20% of the population ever needs to attend a nursing home, because with home care and assisted living, we are able to stay in a community setting, which most of us prefer. Nursing home stay, though, you can see it's about $131,000 a year, and that's about a 2.5-year stay. And this is where you're going to have doctors on staff, nurses. You need more medical attention. Let's go to the next slide, please. So now we're going to talk about the Washington Cares Fund. This is a new name for the Washington Trust Act. And when you go to the website, you will see that they've really summarized well what we just talked about. They're trying to address the need that many people will need care, reduce the burden to family members, and help people protect their savings they work their whole life for. That includes their home. We go to the next slide. So who made up this group, this commission? And you'll see that there's 4 departments plus a 21-member board. So I just want to quickly explain what each of the departments is responsible for. So the health, you're going to see the Healthcare Authority. They are responsible for tracking the use of your benefit. They're going to approve the services that can be provided and establish criteria for how the benefits are going to be paid. They're also going to work with establishing the rules for benefit coordination. That's a big question that comes up. That's coordination between Medicare, labor and industries, and private long-term care insurance. Now, the Department of Social and Health Services, they're going to approve the payments for the type of care you want. They're going to find the providers. They're going to, register them, make sure they're doing their job. They're also going to prepare any electronic materials about any program changes that need to take effect, plan design, any updates. Employment Security Department, ESD, that's the one we're hearing a lot about. They're going to be collecting the premium. They're going to be monitoring the solvency of the program. They are looking to coordinate this with the Family Medical and Leave Act, how you do reporting, how you collect the tax. They're also making the determination of a qualified individual and who can be and what's an exemption from this program. And lastly is the Office of the State Actuary. Beginning January 1st, 2024, they will be performing an actuarial audit and evaluation, and they'll be making recommendations to the council as to the solvency of the program, which may mean there has to be a redesign or reduced benefits. They may have to have increases in the cost. Okay, let's go to the next one. So what does the fund cover? It covers everything, and you can see very heavily regarding home care and the different options available. And all of this is listed on the website, and I do recommend that everyone go to that website. It's www.wacaresfund.wa.gov. You can sign up for newsletters and updates. Okay, let's go to the next slide. And it continues on, as you can read, with a lot of support in the community. which is wonderful. Okay, let's go to the next slide. The overview, Long-Term Care versus Trust Act. And let's go to, I think that's you, Liz.
Yes, that's me. Next slide, please, Kim. So let's talk generally about what the Act does. First and foremost, the Act imposes a payroll tax on compensation earned by employees. That payroll tax starts in January of next year, and employers will need to be ready to implement the withholding and payment of that tax. Flash forward 3 years, benefits will begin to be paid in January of 2025. That's the first time that the trust will be making benefit payments available to residents of Washington State. The benefit will be $100 a day, but there will be a maximum benefit for your lifetime of $36,500. And these amounts will be adjusted for inflation based on the Washington Cost of Living Index. And as Christine said, there will be a lot of monitoring of what these amounts should be in the coming years. Next slide, please. So these are the important dates that you need to have stuck in your brain because they're the salient dates that everybody here is keying off of. October 1, 2021. That is the date that the public website from the Washington State is going to be updated with lots of program and premium assessment information. There is already a website there, but we expect that in October, a lot more guidance is going to be given out and a lot more communication pieces that employers can use to help employees understand the tax and what is expected of them. November 1, 2021 is also a very important date if an employee wants to opt out of the tax. And note, that is the date by which an employee must have in hand coverage, alternative LTC private coverage. It's not that you just apply for LTC coverage, you actually have to have that benefit or that coverage in hand. And we'll talk a little bit more about the opt-out process a little bit later. Then from the period beginning October 1, 2021 of this year through December 31, 2022, so the end of next year, if an employee wants to opt out, they will take that opt-out letter that they get from the state and they will apply for an opt-out letter that they get from the state. And once they get that, we'll give it to the employers that they have so that they can not have to pay the payroll tax. Again, the payroll tax effective date is January 1 of next year, and then you can start filing claims in 2025. Next slide, yes, thank you. So what exactly is it that an employee needs to have in order to be able to access benefits under the Act? Well, first and foremost, care must be provided in Washington State by an approved provider, either at home or in a facility. Again, you need to be in Washington State to be able to access this benefit. And you need to have help with 3 out of 10 activities of daily living, ADLs. And Christine talked a little bit about that earlier. Next slide, please. So this is a chart that lists the 10 different activities of daily living. On the right side is the Washington list, and it includes bathing, dressing, transfer assistance, continence, toileting, eating, medication management, personal hygiene, body care, ambulation, mobility, and cognitive impairment. And that list is very similar to the HIPAA list, but not exactly the same. So those of you who are familiar with the HIPAA list, it's close, but not quite exactly what you had been expecting. So Washington is a little bit different. Next slide, please. So then once you need care in 3 out of the 10 ADLs, and you're asking for care in Washington State, there's a third prong that you need to have, and that is you need to be vested in the benefit. And I think a lot of us are familiar with vesting concepts from retirement plans, 401k plans, for example. Well, this is similar, but there's a tweak to it. there are two different ways to vest in an LTC benefit under the Act. First, you have at least 10 years of contributing to the fund, so 10 years of employment without a break of 5 or more continuous years. And you work at least 500 hours, or you contribute at least 500 hours per year during those 10 years. Or the second way is that you contribute to the fund or work for 3 of the last 6 years as the time that you apply for the benefit, and you have at least 500 hours of service during those years. So, for example, if you work for 10 years, you will always be vested in that benefit and you cannot lose it. However, if you are not working for 10 years, you may vest at one point in time and then lose vesting because you need to have 3 of the last 6 years at the time you apply for the benefit. This means that people who are retiring shortly within the next couple of years may never ever be able to qualify for this benefit. So something to think about. Next slide, please. I'm going to turn this over to Helen, who's going to talk about which employees are impacted by the payroll tax.
Thanks, Liz. So who does the Act apply to? The definitions for the Long-Term Care Act for employee, employer, and employment are the same as in the Paid Family and Medical Leave Act. So many of you are familiar with that law as it has just gone into effect in the last few years, and people were starting to receive benefits in January of 2021. I'm sorry, January of 2020. So this is very similar as far as who it qualifies for and what's covered. So starting in January 1 of 2022, deductions are going to apply for any W-2 employee working for an employer in the state of Washington. This means that the Act does not apply to independent contractors. It doesn't apply to self-employed individuals or those who are engaged in what's defined as casual labor. It also doesn't include any federal employees or employees of a federally recognized tribe. But the Act does cover employees of the state of Washington and all local government employees. So employment is broadly defined as personal service of whatever nature performed for wages or under a contract calling for the performance of personal services, written, oral, express, or implied. It can include work performed in or out of the state of Washington if, number one, the service is performed in Washington, or the service is not localized in a specific state, but some of the work is performed in Washington, and the employee is based in Washington, or if there's no base of operations, then the place from which the service is directed or controlled, and that's in Washington, or the base of operations from which such service is directed or controlled is not in any state, but the individual lives in Washington. So what does that mean? That means if you could be subject to the Long-Term Care Act if, number one, you work in Washington, number two, you are based in Washington or report to someone in Washington and you work at least some of your time in Washington, or your base of operations is somewhere other than where you work and you live in Washington. So those are the 3 categories of employees in which you may be subject to these payroll deductions. Importantly, there is an exemption for collective bargaining agreements, and this is very similar to the exemption from the Paid Family and Medical Leave Act. So if your employees are subject to a collective bargaining agreement that was in effect as of October 19th of 2017, they do not have to receive payroll deductions starting in January of 2022 until the existing agreement is reopened or renegotiated by the parties or the agreement expires. So this means if you have a CBA that was finalized before October 19th of 2017, that nothing happens at all for those employees until the CBA expires or the CBA has been reopened or negotiated in its entirety. So if you had an agreement that was dated October 1 of 2017 and it expired on October 1 of 2020, and the parties extended the agreement, it's still determined to be an expired CBA. So an extension doesn't count, and the employees are still going to be subject to the payroll tax as of January 1 of 2022. Also, if your CBA was from October 1 of 2017 and it was reopened and renegotiated in its entirety, your employees are going to be subject to the payroll tax. But if you had a CBA from October 1 of 2017 that's still in existence, let's say it doesn't expire until October 1 of 2022, your employees are exempt from the deductions even if you negotiate a specific section of the agreement. For example, if you entered into an MOU to accommodate the new Paid Family and Medical Leave Act, and that's all, and the rest of the agreement is still in effect, it's not considered a reopening or renegotiation of the agreement. Also, negotiations of future contracts do not constitute a reopening or a renegotiation. However, as soon as that CBA expires or you reopen the CBA for a new negotiation, all of the subjects are then going to become subject to the payroll tax at that point. Okay, so next slide, please. So because of these definitions, there are a few eligibility traps built into the law. The first is that you might work in Washington for the next 10 years and pay into the long-term care fund. But then you decide to retire and you want to move to Palm Springs and soak up the sun by the pool. Let's say a few days into your retirement, you trip over your pool chair and hit your head on the cement. And then you find you're in need of long-term care services. Unfortunately, because you no longer live in Washington, you're not going to be able to collect those benefits, even though you've paid into the fund for 10 years. Okay, another trap, you might live in my hometown of Portland, Oregon, because you hate pumping your own gas and you love the Portland Trail Blazers. However, you drive across the bridge every day and you work in Vancouver, Washington. Because you're working in Vancouver and you're in Washington and you're reporting to an employer who's in Washington, you're going to be subject to the payroll taxes. But when you're out hiking and you slip on a wet log and require long-term care services, unfortunately, you're not going to be able to collect because you live in Oregon. And then third, you might pay into the plan for 2.5 years starting in 2022. And let's say you work through 2026 when you retire. You're enjoying your active retirement until you slip on a banana peel in a store in 2028 and you require long-term care. So even though you've paid in for 4 years, you're ineligible to receive the benefits because you only worked 2 years out of the 6 years prior to your need for the benefits. And that's what I think Liz was mentioning. So some of these issues might be addressed, some of these problems, I think, with the ability to collect benefits may be addressed in the future, but at least for the time being, these are the situations in which you might not be able to receive the benefits that you've paid into the system. Okay, so next we'll turn this back over to Liz to talk about the opt-out process.
Hi. Yes. So as Helen has said, there are some impediments to actually becoming vested in this benefit. And thankfully, the legislature has given employees a way to opt out if they would like to. And I know that Christine has testified at Washington State Legislature trying to help them understand sort of what makes sense timing-wise. So the first thing to know about this process is that it is a permanent opt-out. Once you're out, you can't get back in, and once you're in, you can't opt out. The period for which you can apply, during which you can apply for an opt-out is October 1, 2021 through December 31 of 2022. You will need to go onto the Employment Security Department ESD website to apply for an exemption. And you will have to fill out, obviously, some information, including an attestation that you purchased qualifying private LTC insurance prior to November 1, 2021. And again, that is buying and actually having in place that benefit, that policy. The November 1 date sort of bounced around in the legislature over the past few months, but the November 1 date now seems to be the one that's sticking. So that's an important date to remember. You'll need to give them some information about yourself, your age, and the ESD, of course, will verify whether or not you actually have the coverage, and they may request additional information. So again, as I said, the opt-out is permanent. Even if you later drop LTC insurance, you will not be able to opt into the process. Or if you later obtain private LTC insurance, you can't undo where you are in that process. If you're out, you're out. If you're in, you're in. Next slide, please. Okay, so we do have an opt-in provision for the non-employees that Helen was talking about. Sole proprietors, partners, and independent contractors can opt in. And that can be done as early as January 2022. We're still, I think, waiting for some guidance from Washington State about what that process is going to look like. But you need to do that before January 1, 2025. Or if you first become self-employed later, then you need to do that within 3 years. As I said, the opt-in applications are going to be available later, we think in January. And one thing to think about is that maybe now someone is a sole proprietor or a partner. That does not mean that that person will always be a sole proprietor or partner. And if that person wants to opt out, he or she or they will need to do it during that period that we talked about before. So you might not be subject to the tax now because you're a sole proprietor, but if you become a common law employee later on, you will be then. So think about that. That's something to think about in the future. Next slide. So this is sort of the process. The ESD decision will come to you. You'll get a letter approving, hopefully, from the ESD saying that you are exempt from the program. The employee must provide a copy of that letter to the employer and to all future employers, because that's the only way that an employer will know whether or not the employee has opted out. This is a process that the employee does. I don't believe that employers are going to be involved in the actual application to the state. You can also, unfortunately, get a declination or a decline letter from the ESD, a denial letter, and they will tell you why you were denied. And if you disagree, you can appeal to administrative law judge to reinstate your opt-out. I think we'll get more information about what that process will look like. But this is just sort of a thumbnail sketch of what correspondence you will be getting from the state in an opt-out process. Next slide. So exemption applications are only going to be accepted from October 1, 2021 through the end of next year. It's important to know that the approved exemptions are going to take effect on the first day of the quarter, immediately following approval of the exemption. So if you are approved in February, then April 1 is when that exemption will take effect. As we mentioned before, the exempt employee is going to have to provide that notification to all current and future employers of the exemption. So there will be a record keeping duty, not only for employers, obviously, in order to implement the payroll tax, but also for the employees so that it knows where that exemption letter is in the house and can replicate it and give it back to the next employer. And if an exempt employee fails to notify an employer of the exemption, then that exempt employee is not entitled to a refund of any premium deductions made before notification is provided. So employers, you will need to keep track of when you're getting these notifications and make sure that you have something on your books to show proof of when receipt occurred. I'm now going to turn it over to Christine to talk about what qualifies as private LTC insurance.
$1 million question, what everyone asks. So I'm going to, if you go to the next slide, and this is a really important code to note, RCW 48.83.020. This is where all the answers are. One of the questions has been, is there a minimum amount of coverage we need to buy? And that's been going back and forth. And as far as we can tell, this is the only definition the state has given, which tells us there is no minimum requirement. A lot of people are thinking they'd have to meet what the state's offering, $100 a day for 1 year, equaling a $36,000 benefit. Now, just recently, I just received it today, about an hour ago, an email where the Washington Cares Fund, and I'm going to repeat this website again because I know a couple people had a question on it. It's WACARESFUND.wa.gov. When you go there to that website, they used to have a section called Private LTC Insurance. It's now called Exemptions. And they will refer back to this code. So I'm going to go through this code with you. And they use some of the same terminology. So you'll see in the first section here that's folded that the coverage has to last at least 12 consecutive months with some type of expense being incurred that'll be paid for in a setting other than a hospital, and that there's payments made on cognitive impairment or ADL loss. Okay, let's go to the next slide, please. So this can include group insurance, individual annuities in life that has some sort of rider or supplement for long-term care. What it does not include with life policy, and again, you will see this on the website, an accelerated death benefit that is only for a terminal illness. It does not talk about cognitive impairment, long-term care, or ADL. If it's a lump sum, or the condition of the benefits or the eligibility, there's not a condition for benefits for the eligibility, meaning no ADL or cognitive impairment. If we go to the next slide, you do have to have a qualified long-term care insurance contract. And what is not long-term care insurance? Because there's a lot of different variations out there. It could be a Medicare supplement. Some people could call some basic hospital insurance, hospital confinement, an accident type of program, a disability program. Okay, they do not qualify. They will specifically talk about on the website and what we know, anything with critical illness. There are some life policies that have a critical illness rider. They sound exactly the same as long-term care. They probably pay out the same, but they are not considered a qualified contract. Group long-term care insurance, it's delivered in the state. And if we go to the next page, okay. And this is where one or more employers that they can offer this plan, or through a professional trade or occupation or association. You'll know that it's a group contract, as your employer or association will tell you. It's either group or individual. And I think that is it that I have to review for the exemption. Go to the next slide. No. The qualified contract, a lot of us have heard the terminology of the 7702B of the Revenue Code. And that's where it defines what a long-term care policy is. And this again is where we came up with the 2 out of 6 activities of daily living and cognitive impairment. So if your rider or long-term care policy meets this, which most of them do, there are only a few out there that don't, due to critical illness on the Life Plus LTC or a permanent disability. But other than that, they clearly meet the long-term care, and the insurance company can confirm that for you. If we go to the next slide. Two big questions. Can you participate in both? Can you have the Washington Fund and have private long-term care insurance? And the answer is yes, you can. I don't know that many people would do that. For most people, that long-term care insurance makes sense. They would more likely apply the money that they would have used for the tax towards a program. Because as you've noted, a private policy is portable. You take it with you when you leave employment. You can use it at any state, and there's no vesting period. And then I want to bring up coordination of benefits again with the code, because that is a question that's always asked in relationship to a private long-term care insurance. But we want to keep in mind that this could relate to Medicare and that L&I. Okay. Go to the next slide. All right.
Okay, so I'm going to jump back in and start talking about employer responsibilities. And so currently, there's no time-sensitive legal obligation for employers regarding the Long-Term Care Act, like providing notice. But you may find that you've already been receiving questions from your employees, partially because of all of the, I think, updates and newspaper news clips and things that are probably announcing this, because it is the first program like this in the country. So I think it's a good idea for you as employers to become familiar with the process, to start preparing for what you're going to do once your obligations kick in, and be ready to answer any questions that you might have. So again, as a reminder, your employees only have this one opportunity to opt out, and they have to actually have secured their insurance by November 1 of 2021. I saw that there was one question about what do we do for new employees that come in after 2022, and can they opt out? And right now at this point, there is no provision for that. I mean, unless they already had long-term care insurance prior to November 1 of 2022. So I think that'll be an interesting question to see as this act kind of progresses. But for those employers who have organized workforces, you should review your existing CBAs to determine whether they were signed prior to October 19th of 2017, and whether they will have expired prior to January 1, 2022. And again, this is still the case even if you've negotiated an extension past January 1 of 2022. And so for those employees, you need to make sure that they're going to be ready, or that you have a separate process for them with regard to deductions. And then you have to prepare your system for employees who are going to want to opt out of the Act. Okay, so according to the terms of the statute, the ESD is supposed to accept applications for exemptions starting on October 1st of 2021, and then that goes through December 31st of 2022. So a full year into the time period when deductions are going to have been taken. But as soon as the employee receives their letter, their approved letter that they are exempt from the program, they should be able to provide that to you. Again, I think Liz referenced, but you, as an employer, you want to keep a copy of any tax exemption records. That's part of your requirement under the Act as an employer. And as soon as you receive the notice, you may no longer deduct any premiums from that employee's paycheck. So that's important. Somebody, I think, asked in one of the questions, what happens if the employee gets their approval and they're exempt, but they delay in providing it to the employer? If that's the case, then you have no obligation, because your obligation begins as the employer once you receive a copy of that tax exempt letter. And so as soon as you receive that exempt letter, then you stop deducting any of the premiums. If, as the employer, you continue to deduct after you receive a copy of the exemption letter, then the employer is going to be responsible to pay those premiums back to the employee. And that is not something that's going to be reimbursed by the ESD. The ESD will just profit from that mistake by the employer, and you're going to have to pay that out of your own pocket. Okay, next slide, please. So although the guidance hasn't been formalized yet from the ESD, we expect that the remittance of the payroll premiums will be very, very similar to those used in the paid family and medical leave law. And so now, again, most of you as employers in Washington are familiar with that process, but it's going to be very similar in that you provide quarterly reports, which will be due at the end of the first month following the quarter. And then you remit all of the premium payments for each employee as reported on those reports. That's very likely going to be the same process for this long-term care premiums, of course, with the exception that there's no employer contribution necessary for these deductions. And if your employee has provided notice that they're exempt, you need to prepare to submit those exempt letters to the ESD as well, so that you're keeping track of that. Next slide, please. So because of the individual exemptions and the fact that the CBA is negotiated prior to October 19th of 2017, we'll have different expiration dates and or different dates that the agreements are reopened. Deductions might not be so easy. You're going to have to set up different categories of your employees. Number one, those who will never have any payroll tax deducted because they've opted out of the program. Second category will be those whose payroll will start at the expiration of the CBA or whenever the CBA is renegotiated or reopened. And then the third, those who will begin to have a deductions taken right on January 1st of 2022. So employers should be working with their payroll departments or the payroll companies to treat these employees separately and instruct them how and when to begin the payroll deductions as appropriate. So what is going to be deducted? The plan is, the Act so far sets up that you're going to have 0.58% of all wages that will be withheld, and there's no cap. So, and I know Liz already covered this a little bit, but important dates again to remember is that January 1 of 2022, that's when deductions will begin for most people, and then April 30th of 2022, which is the first month following the first quarter of 2022, that's when those reports and payments will be due to the ESD. Okay, next slide, please. Okay. This slide has some of the publicly available information that we have so far, and I know Christine has mentioned this, but it is important and it will be a resource for you as you go forward because there is a lot that's still kind of undetermined and unknown. So you can click on the link for employer information along with other detailed information about the Act and the fund. But you can sign up for updates and monthly messages, and then there's webinars that are expected to be provided by the ESD this fall. Next slide, please. This is another informational slide from the ESD that is providing information saying that they're on track right now to begin assessing premiums January 1 of 2022. Okay, and then next slide. So the text of the Long-Term Care Act defines wages or the wage that's supposed to be measured as all remuneration paid by an employer to an employee. So this is the same definition as used in the Paid Family and Medical Leave Act. And what we have listed here is the guidance, I think, that the ESD has provided with regard to the Paid Family and Medical Leave Act. So it includes salary or hourly wages, commissions or piecework, bonuses, cash value of stock if part of a compensation package, cash value of gifts and prizes, holiday pay, PTO, this includes vacation, sick, and associated cash outs. Separation pay, such as severance pay, termination pay, or wages in lieu of notice. Compensation for use of specialty equipment, performance of special duties, or working particular shifts. Stipends or per diems, unless provided to cover a past or future cost incurred. So basically, anything of value that you're providing to your employee needs to be included in the wages, and 0.58% of that needs to be withheld and reported to the ESD each quarter. It does not include tips. That's not something here on our slide, but it's also important for employers who have employees that receive tips. Reimbursements of expenses, necessary business expenses, supplemental benefit payments for health insurance, these other kinds of premiums, and any payment into a retirement or disability plan. All right, so go back to Christine.
I wanted to show you an example here of what the current tax looks like. And I am going to call it a current tax because, as I mentioned earlier, for the solvency of the program, there could be a plan design change. The rates could be different. But currently at 0.58%, if you have $100,000 of W-2 income, your tax is about $580 a year. And you can see as the greater income, the greater tax you pay. So I wanted to show an example, if you go to the next slide, of current products that are in the marketplace today. Now, there are a lot of employers that already have long-term care in place, and those rates could be much lower than this. But I'm going to show you an example. If you had a group plan and the benefit could range between $50,000 to $150,000, and if you're age 35, your premium could be $34 to $42 a month. Now, if you purchased it at the age of 40, you can see it cost a bit more. How the long-term care plans work is when you purchase a plan at a specific age, let's say I bought it at age 40, I will always have that rate of age 40. The rates don't increase every year as I age. That's one of the unique factors of this product. Now, in the second column over, you're going to see Washington Care Fund. Now, how they calculate it is based on your income. So we'll go to the person who has $100,000 of their W-2 annual income. And at the current tax rate of 0.58%, that'd be $48 a month. So, and that just depends on your age. When you look, if I am making $100,000 a year and I'm 35, well, I can very much get a program, richer, more comprehensive than state program, for probably less than the tax I pay. Now, if I'm in my 50s, making $100,000 a year, you'll see at age 55, that program for private insurance will be between $47 and $58 a month. So I might be paying a little bit more. And this is just an average. There are a lot of different programs out there, and then they could cost substantially more. A couple questions that I saw come through that I wanted to answer. And yes, the question has always been, is there a minimum plan design? And as what we can tell from the website that was just updated, they are just referring back to the RCW code, telling us that if the plan meets these qualifications, it's all they've asked for. They have not said anything about any minimum plan design. So we believe that in most cases, we won't have a minimum plan design people have to purchase. Another question that came through is, what if I'm under the age of 40 and I can't find long-term care insurance? Well, that is a good question, because there's an individual private long-term care insurance and a group. And in the individual, there's some plans that you have to be 40 and older. Okay, so it is challenging. One plan maybe you have to be 30 and older, but to find a plan 18 to 29 is difficult, if not impossible. So if the employer can offer some type of plan, most likely these will also have easier access for health, because that's where a couple other questions came through. The group plans, a lot of them have guarantee issue. That means there's no health question. That is only offered during the initial enrollment. And another question that comes up and has come up here is, what if I purchased the long-term care insurance, file for the tax exemption, receive that tax exemption letter, and then cancel my coverage. Would the state ask for a recertification? Currently, the way the law reads, they would not. Please note, currently, the way the law reads, laws can change. This question has come up. It's been a topic of conversation. I wouldn't be surprised if something like that changes. So it's just something you'd want to ask yourself. Does it make sense to make sure you're fully protected to purchase a long-term care plan, help you protect your savings, and it will protect you to avoid the tax should a recertification come into play later on? All right, turn it over.
Thank you, Christine. So one consideration that has come up is whether or not this act might be preempted by ERISA. And this is a very general, high-level discussion of ERISA preemption, which is a very complicated topic. But as you know, ERISA, the Employee Retirement Income Security Act of 1974, ERISA, it preempts state laws as they relate to employee benefit plans. And in very general terms, what that means is that to the extent that a state law tries to regulate or govern an employee benefit plan that's subject to ERISA, that federal law, is going to trump the state law. So the question here has been whether or not the act relates sufficiently to an employee benefit plan such that it is preempted by ERISA. Well, the provision of long-term care benefits by an employer on behalf of its employees can be an ERISA plan. And therefore, there is an argument that this act would be or should be preempted by ERISA. However, in the Ninth Circuit, which is where Washington State is, this is a very difficult question. It's very difficult to prove a case of ERISA preemption. In the past, the Ninth Circuit has indicated that in situations where an employer is not required to set up, establish, or modify its own employee benefit plan, state laws and regulations will not be preempted. In this instance, Washington employers are not required to set up or amend LTC plans. Rather, they're simply processing the payroll tax, and the Washington State Trust is going to be paying the benefits and making determinations of who is eligible to receive benefits. So therefore, there's an argument that this really is not a case in which preemption should occur. It's very possible that we have not heard the last about preemption here in this particular topic. And it would be nice if Congress would weigh in on some of these state laws that seem to be proliferating across the country. And it would make things, I think, a lot easier for employers if there would be just one law that applies across the board, but that is not the way things are occurring right now. And then timing concerns, I actually would like to ask Christine. So if you're an employer and you're thinking about putting in a long-term care plan, how long will that take and what does that process look like?
It would take about 3 to 4 weeks to receive a quote or a proposal of all the carriers that are offering a product. Once the employer decides, yes, I want to move forward, it will probably take about another 2 to 3 weeks for all the systems to get up and going. And then about a 2 to 3 week enrollment period. Once an enrollment period has occurred, we need about 30 days from the end of the enrollment to have an effective date. So as I've listed all these dates out, let's say that an employer is able to enroll a program in August. The enrollment ends at the end of August, and the effective date would be a September 1st or an October 1st. So you can see how close we're butting up to the deadline of November 1st. In addition, there's many employers looking for coverage right now. And so it's unprecedented what the carriers and we're all going through, trying to get as much help out as we can, getting products available. There are limitations and capacity limits for enrollment. So if it's something an employer is considering, sooner than later, and there's really no guarantee that you would be able to put a plan in.
Okay, thank you very much. I think that gives employers a very good idea about kind of timing and process, because I think, as the slide says, the sooner the better. Why don't we turn to a couple of Q&As? Let's see. How many years does an employee need to pay into the Washington LTC tax before they can receive the benefit? Well, there are, as I said, two ways to vest. One, you work and contribute to the fund for at least 10 years without a break in service of 5 or more consecutive years, and you have 500 hours of service during those 10 years. Or you've contributed to the fund for 3 of the last 6 years at the time you apply for benefits and have at least 5 hours during those 3 years. So here are a couple of simple examples. An employee works at least 500 hours for the period beginning 2022 through 2031, 10 years. The employee can apply for benefits thereafter when he or she needs them, and the application for benefits can occur at any time. You do not lose vesting in that particular instance. However, in the second example, you may lose benefits, eligibility for benefits. An employee works at least 500 hours for the period of 2022, 23, and 24. The employee can apply for benefits during the period of 25, 26, and 27. But if you don't have enough hours after that date, then you will lose your eligibility for benefits. So, and if you are close to retirement, it can be that you never vest in this benefit, even if you're paying in. Helen, if an employee lives in Idaho and works in Washington State, are they required to contribute?
Yes. If your employer is in Washington and even if you live out of state, and assuming, well, let me back up. Not a hard yes on that. If you do some of your work in Washington and your employer is based in Washington, then you are subject to this law and the deductions. So oftentimes people will come in for 1 or 2 hours, or they'll work a little bit in Washington. Maybe they'll go in for training or something, and then, you know, and especially now that we're in kind of the weird remote working situation where people are at home, I think that is going to turn on the facts of your employment and how it is that you're actually managing your work. But if you work some of the time in Washington and your employer is in Washington, even if you live out of state, you are subject to this law. I think for employers in general, you probably want to follow the same rules that you're doing for the Paid Family and Medical Leave Act. So to the extent that you're already making deductions under that law, this is probably going to be very, very similar.
Okay. One question sort of riffing off of that is, what about collectively bargained folks who are not subject to the tax right now? Do they still need to go through the exemption process if they want to during the regular period that we discussed before? And the answer is yes. For now, that is the only time period that you can opt out of the tax, even if you are not immediately subject to it. And I think that might be about it. We're at 12:59. I do want to read the CLE code. It is SS Seyfarth Shaw 3501. SS 3501. And I want to thank everybody for attending, and have a good rest of your day. Thank you.
Thank you, everyone.
Thank you.